My lady and my lords, when we broke, I was just dealing with justification. There's one final point I should perhaps make about justification. My learned friend prays in aid the sort of well-established principle that there are circumstances where a bright line, the need for a bright line, can be justified. In my submission, that principle it can't be relied on in these circumstances, because the whole point is that the bright line, if we're right in our argument, discriminates against everybody. This isn't a situation where there are some hard cases at the margins. This is a case where the bright line discriminates against everybody, and that can't be justified by the principle that one needs a bright line. In my submission, this is not a case where that principle has any real relevance. So if I can move on from justification to retrospectivity in the Human Rights Act, obviously there are sort of, as we've accepted in our statement of case, a range of permutations here as to when a violation is found and what the nature of the violation is. But the most obvious violations, if we're correct, are either that there is a continuing breach or discrete decisions post the Human Rights Act. If either of those points are correct in our submission, we clearly come within the terms of the Human Rights Act, and there is no problem with retrospectivity, applying the approach in particular in McCaughey. Section 22(4) of the Human Rights Act, as is well known, which is at Volume 1, Tab 4, Memory Stick, page 219, says, paragraph B of subsection 1 of section 7 applies to proceedings brought by or at the instigation of a public authority whenever an act in question took place, but otherwise that subsection does not apply to an act taking place before the coming into force of that section. Now, obviously, not least in KU, there's been a recognition that there are still potentially issues to be raised about the meaning of that. But in our submission, as I say, we clearly come within the principles identified, or the appellant clearly comes within the principles identified in McCaughey. In my submission, in McCaughey, it was essentially two factors that led the court to conclude that the Human Rights Act could be relied upon, despite the fact that the death in question occurred before the Human Rights Act. The first was the fact that there were fresh decisions essentially being taken after the Human Rights Act came into force, and that those fresh decisions could potentially violate the European Convention. And it was those factors that led the court to conclude a second thing, that this was a situation where the mirror principle, the principle that essentially someone should be able to litigate domestically arguments that they could litigate in Strasbourg, should apply. In my submission, that is clear from all the judgments, all of the majority. McCaughey is in Volume 1, Tab 17, page 471. As I say, in my submission, one sees the two factors that I've just identified in all.
Well, the first I understand completely. The second would apply to absolutely everything. So I'm not sure, stated as broadly as you do, it would apply to.
Well, I'm suggesting it's the cumulative effect of those two. It's the fact that there were fresh decisions. And that... So
it's a cumulative effect, that's not a freestanding one?
Not a freestanding point.
Right.
It was the combined effect of both of those points. Right. It was actually a better way of putting it, probably, than the way I just put it, was to say that the first point led to the application of the second point in the circumstances of the case. That's why it's cumulative. It's not a freestanding... In my submission, one sees what I've just said, sort of firstly in the judgment of Lord Phillips. One goes to Memory Stick, page 493, paragraph 51 of the judgment. What Lord Phillips relied upon was the fact that there was an inquest that was going to be held into the deaths. And the United Kingdom, as a result of the freestanding obligation under Article 2, needed to ensure that inquest complied with the procedural obligations. So as I say, Lord Phillips is identifying the fact that fresh decisions will essentially be taken and that they are decisions that will potentially engage the Convention. He then went on at paragraph 57 to identify the basic problem sort of that underlies any argument about the retrospective effect of the Human Rights Act, which is the potential for two principles to be in conflict. The first is that the Act doesn't have retroactive effect, but the second is that the Act should mirror the convention so that essentially people should be able to litigate in the United Kingdom arguments that they can litigate in Strasbourg. What he then identifies, essentially, is that in paragraph 61, is that because in the Scylla case, it had been identified that Article 2 obligations don't continue indefinitely, but that they do essentially apply to current events, in that case the inquest, that was essentially sufficient to mean, as he concluded in paragraph 62, the mirror principle should apply. And that's why I was saying the 2 points are cumulative. What Lord Phillips in my submission is doing is identifying decisions that following Scylla potentially give rise to convention obligations, decisions that were taken after the Human Rights Act came into force. And that was why he then went on to hold the mirror principle applies. That submission, in my submission, is also consistent with the judgment of Lord Hope. Lord Hope is paragraph 78 and 79. Paragraph 79 in particular is where Lord Hope talks about the idea of bringing rights home. And as a result of that, there was nothing in the 1998 Act to prevent the coroner having to comply with Article 2 when they conducted the inquest. My lady, Baroness Howard, at paragraph 87, distinguished the McCurr case on the basis that essentially that was a case where there was an attempt to compel an investigation, whereas McCaughey was a situation where there was an inquest. At paragraph 89 to 90, my lady identified the fact that there was going to be an inquest, albeit, I should note in passing, the investigation itself had started on the 2nd of April 1993 before the Human Rights Act. But my lady concluded that that was not an issue that gave rise to retrospective operation of the Act because public authorities were required to act compatibly with the Human Rights Act at the point in time when the inquest was being heard. That's, as I say, paragraphs 89, end of paragraph 89 and paragraph 90. Lord Brown, paragraph 101, essentially adopted the same approach, adopted the judgments of Lord Phillips and Lord Hope in relation to the fact that the inquest was outstanding. My Lord Kerr, paragraph 111, indicated it was entirely consistent with the Human Rights Act, essentially to apply the Article 2 obligation to the inquest that was outstanding. Lord Dyson, paragraph 133, it indicated that because essentially there was a freestanding procedural obligation, one that would potentially, well, I would add, one that was potentially also engaged by the inquest, that was where the mirror principle applied, paragraph 134. So in my submission, what is quite clear is that the court is identifying the fact that fresh decisions needed to be taken in the inquest context. Those were fresh decisions that engaged the convention, and that in those circumstances, the Human Rights Act applied. It didn't matter that the start of the obligation to investigate had occurred before the commencement of the Human Rights Act. What was critical was the fact that further decisions were being taken. That explanation, or that interpretation of McCaughey in my submission is also consistent with the approach of this court in KU. If one goes to volume 2, rather, tab 20, page 609 of the memory stick, paragraph 94, Lord Neuberger. Referred to the fact that the critical point in McCaughey was the fact that there had been a decision to hold an inquest. That was the basis of the conclusion in McCaughey. My Lord Kerr, paragraph 206. Referred to the reason why Article 2 potentially applied being because of a current imperative. In other words, it was because current obligations arise. And my lady, Baroness Hale, paragraph 293, referred to the critical point in McCaughey being the fact that significant parts of the investigation would take place after the Human Rights Act came into force. So, as I say, in my submission, one sees from that case law 3 points. Firstly, it doesn't matter when the obligation commenced. In McCaughey, it clearly was before the Human Rights Act because the inquest had started before the Human Rights Act was in force. So whenever the breach occurred, or first occurred in this case, it doesn't matter in my submission. The second point is the key point is whether the state is taking action after the entry into force of the Human Rights Act that potentially engages the European Convention. That's hardly surprising that that should be the key point. That reflects in our submission the language of Section 22.4. Section 22.4 refers to the right to challenge acts after the Human Rights Act is in force. And that's why the submissions I started with about there either being a continuing decision or further discrete decisions that potentially violated Article 14 is so important, because if we're correct, there are decisions essentially that bring the Human Rights Act into play, that one could go to Strasbourg about and say there is currently a violation of my rights. And it's in those circumstances the mirror principle applies. The third point is, which I haven't perhaps spent very much time on, but it will be obvious from the judgment, which is that when looking at the approach to the temporal restrictions, it is appropriate to look at the European Court of Human Rights case law, because the European Court of Human Rights case law sheds light on whether it regards an action as continuing or whether it regards it as limited to a point in time before an obligation came into force. And here, authorities such as Curric, which I've already referred to, demonstrate how, in our submission, this is regarded as a continuing state of affairs, because if we're right, for the reasons already given, this is a situation where there is a continuing interference with Article 8 rights. So the sort of difficult issue that was perhaps sort of identified in KU, which is about the extent to which, in fact, one can bring retrospective claims, doesn't really arise, we would submit, in the circumstances of this case. This is a case where the principles established in McCaughey are clearly applicable. The final issue that arises in relation to Article 14 is relief. We proposed, obviously, a declaration in relation to the historic version of Section 50, subsection 9 of the British Nationality Act. And there is a good reason for that in our submission. If our Article 14 arguments are correct, it might be that aspects of treatment, such as deportation, can be prevented. But the basic right to citizenship can't be enforced. And that is because primary legislation prevents that. Section 59 means that as it applies in the appellant's case, means that it's still not accepted that for the purposes of Section 2 of the British Nationality Act, he can rely on his father's citizenship. That's in our submission why a declaration of incompatibility is important. Although, of course, I accept declarations of incompatibility are discretionary, in reality, certainly we've been only able to identify one case where, despite there being a violation of the Convention, a declaration was declined, which was the prisoner voting case. And the reason in our submission for that is because, in many respects, a declaration of incompatibility doesn't place a burden on the Secretary of State, it just makes it clear that there is a problem. And it's one that she can use, if she so chooses, particular powers to correct, but that's a matter for her. The Secretary of State argues that you can't make a declaration in relation to a provision no longer on the statute book, but that misses the point. From the appellant's point of view, the objectionable version of Section 50, subsection 9, is still on the statute book. The transition provisions mean that, in his case, because he was born before the 1st of July 2006, the version of Section 50, subsection 9, continues to discriminate against him. And that means, in our submission, that there is the power to make a declaration of incompatibility. The reason why we can't obtain any other relief, other than a declaration of incompatibility, is that Section 6.2, the Human Rights Act, means that the Secretary of State is not acting unlawfully by failing to treat the appellant as a British national. Section 4 in our submission must be read with Section 6.2. Section 4 is the other side of the coin, essentially, which is where you can't achieve compatibility because of primary legislation. Section 4 provides the answer. Section 4 is the remedy that's appropriate. That essentially deals with Article 14. So far, I've not addressed the Article 8 issues. Those issues arise, as the court's already made it clear, it's well aware, because the case was certified as clearly unfounded. The approach in those circumstances I don't think is in dispute. It wasn't in dispute from the High Court upwards, which is essentially, although the court is conducting a rationality review, in this context there is essentially only one rational answer. If the court concludes there's a realistic prospect of an Article 8 claim succeeding, a decision to certify the claim as clearly unfounded is irrational. That was the test applied by Mr. Justice Dingemans, and which is at paragraph 70 of his judgment at page 131 of the bundle. Nobody's suggested that's the wrong test. In this case, the first-tier tribunal previously found that Article 8 was engaged by the deportation decision in light of the appellant's private life. However, it's also fair to say it found that deportation was proportionate. It did that without considering issues raised by illegitimacy, and that's because it remitted those issues to the Secretary of State. That, in our submission, raises issues both as to whether or not the decision was in accordance with the law and proportionate. We've made reference in our statement of case to whether or not the decision's in accordance with the law, because in our submission there is a real issue in relation to that when the decision to deport itself depended essentially on a decision that was a breach of the Convention. Deportation wouldn't, as we're all aware, be possible without a breach of the Convention. But proportionality perhaps is where the focus of this argument really is. And in that context, in our submission, it's quite clear that the Court of Appeal has, for a significant period of time, recognised historic injustice, and I use that word deliberately, because that's the language used by the Court of Appeal, historic injustice as a basis for finding that a decision that would otherwise be proportionate is disproportionate. The leading authority in relation to that, which sets out the basic approach, is now the Gurung judgment, which is at volume 3, tab 32, memory stick, page 1016. The background to that judgment was that, as the court may well be aware, historically, Gurkha soldiers were treated less favourably than many other non-British Commonwealth soldiers serving in the British Army. That was recorded at paragraph 2 of the Court of Appeal's judgment. That treatment led to an acceptance that there was historic injustice, paragraph 27. No, not only, but when noting that, it's important to recognise that there was no suggestion in the court's judgment that it needed to consider when that historic injustice occurred, no consideration either of whether or not, in fact, it was a breach of the European Convention on Human Rights.
I'm sorry to interrupt you, but I think I've lost track of
Sorry, my Lord,
what exactly we're dealing with at the moment. Are you talking about the question whether the appellant can maintain that he falls within the scope of Exception 1 in Section 33 of the 2007 Act?
Yes, if I remember rightly, Exception 1 is the European Convention exception. And yes, we are, because we're saying, I'm sorry if I'm going slightly quickly, what I was saying was there's no doubt Article 8 is engaged by the deportation, so the issue becomes proportionality, inevitably. And in those circumstances, one factor that's been identified by the Court of Appeal as being highly relevant to proportionality is historic injustice. Now, we're in a...
Is he not relying on Article 14 and his... the same point about the discrimination inherent in treating him as a foreign citizen? Is that not being relied on?
The difficulty is, and the reason why we put it in Article 8 terms, is that we've always recognised the difficulty with putting it in pure Article 14 terms is that you run up against the Section 6 defence. If you put it in pure Article 14 terms, actually, there are two problems with it. One, if you put it in pure Article 14 terms, then you potentially run up against the Section 6 defence.
But why does it make a difference? I mean, either Section 6 exonerates, in a sense, means that the Secretary of State cannot behave any differently.
Yes.
But that's in the refusal to recognise as a citizen.
Yes.
And you accept that the Section 6 applies to that. And that's why you need a declaration of incompatibility, or you'd like to have one.
Yes.
Though in terms which are not a declaration of incompatibility, but that's another question. But we're now on to the certification, as I understand it,
Yes.
of the human rights objection to deportation. Why does it, if the Secretary of State has got a discretion, if it's a breach of human rights to deport, why does it matter which article it is? Surely Section 6 applies to both of them.
Well, the other, that's...
Or neither of them, depending.
Well, not necessarily in this sense, in the sense that it, I wouldn't accept necessarily applies in the same way when one's looking at articles. If there is this concept of historic injustice, there's a second reason also, which I should make clear why historic injustice potentially comes into play, which is potentially also in some senses the most important reason. I mean, if in fact this is a breach of Article 14 for the reasons we've said, although we recognise all we can get is a declaration of incompatibility, the reality is that we recognise that the Secretary of State has almost always acted in accordance with her international obligations as identified in the Declaration of Incompatibility. And so the reality is that it's highly unlikely that the Secretary of State would not seek to remedy the situation. The particular issue, which is why historic, and so a finding of a breach of Article 14, it almost certainly is likely to be sufficient. The reason in part why the focus of Article 8 has been in place is in part if it were to also be found that any breach of Article 14 was a historic breach, if it were only to have occurred at birth, if it were to have been a one-off breach, because at that stage the concept of historic injustice arises. I mean, I accept also that I mean, we've directly challenged if the discrete decisions on Article 14 terms, if we were wrong about the continuing treatment, we've argued that individual decisions are a breach of Article 14. One potentially still has the problem with Section 6, but that's a slightly different issue we would submit to the issue of whether or not to exercise discretion in relation to deportation in a manner that completely ignores any historic illegality that occurred before the Human Rights Act. And that's why it potentially comes into play. I mean, it is very much, it's in part, it is primarily focused on the issue of if the Court of Appeal is correct and any breach of the European Convention only occurred at birth, does that have consequences? And that's primarily why it's there.
I'm sorry, I must be being slow.
No, I'm sure it's...
Under Section 33 of the 2007 Act, Section 32(5), which is the power being exercised in order to deport, well, the duty, in fact, statutory duty to deport, doesn't apply if, inter alia, Exception 1 applies.
Yes.
Exception 1 is where removal would breach a person's convention rights.
Yes.
I would have thought you said that removal would breach the appellant's convention rights.
We do. I mean, if our fallback position in relation to Article 14 was that if we're wrong about this being a continuing state of affairs and discrete decisions have to be considered, one of the discrete decisions that breach Article 14 is deportation, and that's why I addressed briefly the but-for test. And
is that on a very simple basis that plainly deportation is an interference of Article 8 rights, and here he wouldn't be deported if he'd been born legitimate, therefore it's Article 8 plus Article 14?
Well, yes, but that's the way we put it in terms of discrete. But our basic. The basic problem that we've always accepted in relation to Article 14 is that although we've relied upon that analysis as a way of saying that there is a current decision and that this is not merely historic, the other factor that we've always recognised is that that in terms of curing any discrimination, merely stopping the deportation doesn't go far enough, because it is effectively curing one of the consequences of the discrimination. It's not curing the fundamental discrimination. The problem that we had in terms of relief, as I hope we've made clear, with the approach of Mr. Justice Dingemans, is it cures the symptom, it doesn't actually cure the illness, essentially. It doesn't cure the basic problem. The basic problem can only be cured by granting citizenship, and then you run up against the Section 6 bar. And that's the problem that we've recognised. Now, the real reason, as I say, that we have to some extent relied on Article 8 is because if we're wrong in relation to the current treatment, and this is not a current situation, this is a situation that only arose at birth, then we would submit there are still issues in relation to the deportation.
Yeah. And the point that occurred to me is that while reference has been made to Section 6(2) of the Human Rights Act,
yes,
that doesn't apply to, I mean, Section 33 of the 2007 Act is a freestanding provision.
Yes.
That's what we're getting at.
Well, yes, well, in that case, I have been.
Sorry.
At least I think that's what.
And so you're going through the Declaration of Incompatibility, not because you need it in order to stop deportation. You can stop that under Section 33 on your argument, but you want the Declaration of Incompatibility to prevent further and different sorts of interferences of his with his private life.
Well,
arising from his foreign citizenship.
Yes. I mean, that's right. But I think the reason, as I say, that the concern we've had, which is in terms of relief, is that, and this is hopefully explains the approach we've taken to some extent, is that fundamentally the discrimination can only be brought to an end by him obtaining citizenship. And so stopping the deportation is, as I say, to use the language I just used a moment ago, stopping a symptom. It's not bringing the discrimination to an end. And that's the basic problem with discrimination arises because of the statute. And that's why, if you like, that's why our focus is on a declaration of incompatibility, because it's the statute. Now, as I've indicated, the part of the focus of our arguments in relation to Article 8 is really on the situation that arises if the Court of Appeal is correct. And this is purely discrimination that occurs at the point of birth and is not continuing discrimination. And that's really, I mean, one of the problems with sort of arguing in this case is that various parameters, there are various permutations as to when and how discrimination arises. But the particular issue that we rely on in relation to Article 8 is the potential for a finding that discrimination occurred at birth, but no other time. And that's the second reason. It's partly declaration of incompatibility point. It's partly the fact that we still want to, if you like, have our cake and eat it and argue that we can win, even if this was discrimination simply at birth.
So do we have your claim form in the papers? I couldn't find it.
It's not. I don't think it was included in the bundle. We can make sure it's available.
Sure.
Before we go on to that, can I just follow up with my Lord Reed's question?
Yes.
Does exception 1 apply to a breach of a person's convention rights, which would not in fact be actionable in UK law because of section 6.2?
What?
That was the
That's
point
I was getting at.
Yes.
Yeah.
No,
It's a rather revolutionary idea,
well, I mean,
but it may be right.
well, maybe I should consider our position overnight.
Yeah.
The problem that I've had with that is, of course, if one looks at, say, the approach that's been adopted by the courts when considering whether or not one can claim damages for a breach of the Human Rights Act in circumstances where there's a declaration of incompatibility sought and obtained, the court, unsurprisingly, have held that the Secretary of State shouldn't be, or a government department shouldn't be liable for damages if, in fact, it is, by reason of Section 6, entitled and indeed compelled to act in a particular way by reason of primary legislation. And a sort of similar issue potentially arises in this case, in the sense that if the primary reason why deportation shouldn't take place is because somebody should be a British citizen, but they can't be made a British citizen by reason of the British Nationality Act, and so Section 6 provides a defence, then I accept it becomes a little difficult to see why the same arguments essentially prevent the Secretary of State acting in a manner consistent with them not being a British citizen. That's the basic problem that I've always recognised. There is an analogy potentially to be drawn. But can I think about that position overnight?
Yes. I only raised the point because whereas the Human Rights Act, Section 6.1, is a general provision unlawful to act in a way which is incompatible with convention right, and then subsection 2 qualifies that.
Yes.
Section 33 of the 2007 Act is simply an unqualified provision that Section 32, 4 and 5 don't apply where removal would breach a person's convention rights.
Yes. I can see, and I have to be frank, I accept I may have missed a point in relation to this. Our point in relation to Section 33 is focused on Article 8, because in part we've focused on this because we've recognised there is always a risk that our primary arguments are rejected and the conclusion is reached that any discrimination only occurred at point of birth. And that's where we've seen Article 8 potentially coming into play, because in those circumstances there would be, in our submission, a historic injustice, to use the language of the Court of Appeal, And as I say, the difficulty arises in part because we've also always recognised that deportation, although it is only possible because of illegitimacy, and so can properly be said to be a violation of Article 14, it is in some senses the consequence of the denial of nationality, and the denial of nationality is something that can't be cured, and curing the consequences is not going to cure the basic problem. And that's why, in terms of relief, we've always felt that the need is to focus on the Declaration of Incompatibility.
Suppose you didn't have the Human Rights Act at all.
Yes.
You just had the UK Borders Act.
Yes.
How would Section 33(2) fall to be applied? You would say, well, that statute requires the court, on considering an appeal against a deportation decision or a judicial review challenge to a certificate, to consider whether it would contravene the Convention rights.
Yes, then there'd be no issue because there wouldn't be the problem of Section 6. I completely accept in those circumstances it would be straightforward. You'd rely on Article 14 and there would be no issue.
Yeah.
You would be able to say my deportation is a breach of Article 14.
Yes.
But I
have a feeling, I mean, I'm not sure we have it in front of us, but I think Section 81 of the 2002 Act, or it would have been Section 82 that listed the grounds of appeal.
Yes.
My recollection is that at the time it may have had separately, amongst the grounds, breach of convention rights and also separately a breach of Section 6 of the Human Rights Act.
I think it's. I don't think that's.
I'm thinking off the cuff.
Yeah, I'll need to double check, but we can bring that. I'm sure we can bring that. Yes, I think actually what happened was that we can bring that overnight. Yes.
Perhaps we'd better not lose sight of Lord Toulson's question, which is, we don't have the claim form.
No, we will bring that as well. Yes. I mean, just to put that in context, the claim form was initially drafted in circumstances where the focus was purely on Article 14. What happened was that the grant of permission was slightly was a restricted grant of permission, which wasn't entirely clear, and we filed a skeleton argument as amended grounds, which is in the bundle, which set out the alternative ways in which we put our case. And so by the time the argument was before Mr. Justice Dingerman, I think that's, if I'm...
We've got your skeletons in the Court of Appeal.
No, sorry, I thought we'd got the High Court one. We need to get the High Court one as well as the claim form, because that set out effectively the revised grounds. And it was that revised skeleton that led to the consideration of whether or not the claim was clearly unfounded.
But these proceedings are basically judicial review of the certification.
Yes.
That's what they are.
Yes. But they were initially arguing primarily an issue which we accept no longer can be, which is that they were arguing that the legislation could be read compatibly, and so he should be treated as a British national.
Well, that's no longer...
That's no longer part of our argument. But what was put in the alternative was that if that wasn't right, there needed to be a declaration of incompatibility, and also the issue of historic illegality then arose, potentially.
Yes. You have given us the current version of the statutory grounds of appeal on MS 231 and 232, and they take you to Section 6 of the Human Rights Act.
Sorry.
Two, 231.
Thank you very much.
And 232.
Yes, would be
Yes.
under Section 6, yeah.
Yes, they
Now, if that's right, that would make it difficult for us to grant you a remedy, I think.
Yes. Can we double check that overnight? I think my Lord may be right about that may also influence part of our decision. But all I can remember is that the reason why, in some senses, we've hived off the Article 14 argument from the Article 8 argument is essentially two reasons. Firstly, we recognise there was a problem in terms of Article 14 because of what we've already said about Section 6. And secondly, the primary reason for relying on historic illegality was if the court was to address the problem of the Court of Appeal being right, and this being illegality purely at birth. And going back to the point we make, I'm conscious of the time, Gurung, which is at volume 3, tab 32, page 1023,
Yes, you were trying to take us there a long, long time ago. Such is life.
it dealt with the issue of historic injustice in the Gurkha context. It, as I indicated, didn't in that context consider whether or not there in fact had been a breach of the European Convention, although factually there probably had been. It also didn't consider whether or not when it had occurred. What the Court of Appeal did, though, was recognise that where there had been historic injustice, it was a factor to be taken into account in terms of proportionality. One sees that at paragraph 38. What it means by a factor is perhaps, or what the Court of Appeal meant by a factor is perhaps clear from paragraph 41, where the court talks there about how historic injustice is such an important factor, it will give rise to a strong claim. An even further indication of how one approaches this issue is at paragraph 42, where last sentence on the page, going over the page, the court indicates that if a Gurkha can show but for the historic injustice, he would have settled in the United Kingdom at a time when his dependent, now adult child would have been able to accompany him as a dependent child under the age of 18. That is a strong reason for holding it's proportionate to admit the adult child. So the court is recognising that if somebody would be treated differently had it not been for historic injustice, that undermines the state's claim, Secretary of State's claim, that their actions are proportionate. And in my submission, there's good reason for that, because clearly, if someone should have been treated differently in the past, and that treatment in the past would prevent their current treatment, that undermines the state's ability to rely on necessity as being the basis upon which they justify their current decision. Nothing in that judgment suggests one needs to demonstrate illegality under the Human Rights Act before that principle applies. Nothing in that judgment suggests it's necessary to demonstrate even a breach of the European Convention. In my submission, this is a slightly broader concept that reflects effectively the concern that the state shouldn't be able to justify its actions in part because of something it did in the past that it shouldn't have done. That is consistent in some senses with the approach that was adopted to the British overseas citizens cases, which are referred to. And I'll just, given time, etc., make reference to NH, which is in volume 2, tab 25, memory stick page 790, which considered the discrimination against East African Asians, something that started to occur anyway in the late 1960s, well before obviously the Human Rights Act. And Lord Justice Sedley in that case, paragraphs 37 and 38, made it clear that the reason why this principle applied was essentially because of to use his language, the historical and moral dimensions of law, and the fact that historically law had been taken, fundamental rights rather, had been taken away from someone in circumstances where they shouldn't have been. And that, in my submission, demonstrates one shouldn't adopt a very technical approach, which is what the Court of Appeal purported to do. One should look at whether or not there was effectively a breach of what are now accepted standards at the time of someone's birth. And if there hadn't been that breach, and if as a result deportation wouldn't be impossible, that would be something that would weigh heavily in terms of the proportionality balance. And that is ultimately what we say about Article 8, and that's why, as I say, we rely on it primarily, because it deals with this issue of the possible finding that there was only discrimination at birth. We recognise all the points made by the Secretary of State about how deportation of foreign criminals is something that carries great weight, but this is a pretty exceptional circumstance. And ultimately, we submit that is something that the First-Tier Tribunal could properly take account of. My Lords, my Lady and my Lords, unless there's anything further that I can assist.
It looks not, Mr. Turner. Thank you very much indeed. Thank you. Mr. Turner?
No, I have nothing to add.
Thank you very much. Mr. Reiki?
My lady.
I think this time we can mark the fact that this is your very last appearance before this court.
My lady, this time you can.
Yeah. And congratulate you sincerely on the reason why that is the case. For those who do not know, Mr. Reiki is to become the United Kingdom's judge on the European Court of Human Rights in Strasbourg. We congratulate you.
I'm very grateful, my lady. Can I start my submissions effectively by going back to what we say that the relevant decisions here are, because it seems clear from the dialogue between my learned friend and the court this morning, and from the development of this case through the instances, that is at the heart of it. Is there a continuing decision here, or are there a sequence of decisions which bring this case within the Human Rights Act, or is there, as the Secretary of State says, the nationality decision is one that happens at birth, and therefore happened in 1985, and is, we say, outside the reach of the Human Rights Act. And can I then do that by reference to, as I said, the two decisions we say which are relevant and to some extent at issue in this appeal? Before looking at them, I want to stress that both of those decisions, if one can call them that, are of course decisions which were either made by operation of law, that's the nationality conferral, or are mandated by Parliament through Section 32, subject of course to the exception. But it is in both exercising effectively the direction of Parliament. The first decision, of course, and the decision, and the only decision we would say that is the issue of this appeal, and is the decision challenged by my learned friends, is the decision to make a deportation order on the 18th of August 2011 under Section 32 of the UK Borders Act, or the decision of the 23rd of November 2012 not to revoke it. Can I just, and I know we've talked about this and you're probably familiar with them, but could I just ask the court to turn up Section 32, and this is in the supplemental bundle at tab D. So I know I have the wrong reference.
Is it okay to take it from the SFI?
We can take it from the SFI at paragraph 23, MS 53, my lady. It is.
It's E in the bundle, Mr. Eric.
Is it E?
E.
My lord, I'm grateful.
E for Eric.
And there, of course, we have the decision, Section 1, a foreign criminal is a person who is A, not a British citizen, B, is convicted in the UK of an offence, and C, to whom conditions 1 or 2 apply. And we then see in subsection 5, the must make a deportation order in respect of a foreign criminal. The first point I wish to make on Section 32 is, of course, that unlike in all the other cases we've looked at, Genovese, etc., the distinction drawn by this section is between a British citizen and somebody who is not a British citizen. There is in fact no reference here to illegitimacy, and you will recall that in Genovese that of course was the operative part of the legislation. I'll come to why we say that makes a difference. And as a consequence, of course, and I don't think it is disputed, when the Secretary of State applied this section, the appellant was not a British citizen, and in fact he is not now a British citizen. The highest my learned friend can put his case is that he should have been or should be a citizen. There's also no dispute that he's been convicted of an offence and that condition 1 is satisfied in subparagraph 2, that he was sentenced to a period of imprisonment of at least 12 months. Of course, so that is the first decision we say that is an issue, and it is the only decision which is the actual subject of these proceedings. The second decision is then, of course, that which relates to the nationality he holds. And we say that that is a decision which was made by operation of law rather than executive decision, as at the date of his birth on the 18th of March 1985. And it is a result of the state of the law as it was then that he became a Jamaican national and did not become a British citizen. Now, can I again just take these in order, because in my respectful submission it is helpful to just look at the way the law has developed from them and the provisions that applied to the decision under review. Can I perhaps start with the original section 50, subparagraph 9, and again that is in the supplemental bundle at tab C. Now, and helpfully, they're not page numbered, so if I could invite your ladyship, your lordships, to go from the back to see page 9 and go forward to page 5 of that clip, maybe the easiest way to cross-reference it. And your ladyship, your lordships will see in the middle of the page, top right-hand corner, page 5, my lady, you will see in italics the original provision. For the purposes of this act, the relationship of mother and child shall be taken to exist between a woman and any child, legitimate or illegitimate, born to her, but subject to section 47, the relationship of father and child shall be taken to exist only between a man and any legitimate child born to him. So that was the original provision as it applied when the appellant was born. Of course, the position moved on from then. The next stage, just to take us up to date, is the policy that the Secretary of State adopted in 1987, which is probably most conveniently set out in Mr. Justice Dingerman's judgment at MS 122, paragraph 22. And this may be in part, my lady, in response to the criticism that had been levied by the Law Commission, as you indicated earlier on, an initial response. This is...
Well, there's a remarkable coincidence in timing.
My lady, but there we are. So 1987
Yes.
is when the policy was adopted, and the policy is described in paragraph 22. Policy then operated by the defendant provided that if the claimant was a child living in the United Kingdom, his father was a British citizen, and the defendant was satisfied about paternity, I should just pause here, that there is no issue in this case about paternity, and the child was, if 16 or over, of good character, he would be made a British citizen. provision was made for both parents to consent to that process, but the provision of parental consent might be waived if there had been no contact for many years, which is, of course, again, a scenario which factually would have applied here. Perhaps also to note that the good character requirement only started once the child was 16 or over. There was no good character requirement before then. So that was a first attempt by way of policy to address the concerns about Section 50, subsection 9, as it stood at the time. The next development then was this 2002 Act, which was Section 9, which we have at Volume 1, Tab 7.
This policy, did the judge hold this policy operated from about 1987 onwards?
1987, my lord, is when it came in, and that's...
Very much, yeah.
And I think it was accepted by the judge that if he had applied,
Surely.
he would have been successful. And of course, at that stage, up to the age of 18, there was also no issue about the good character requirement, and therefore even that would have been satisfied.
Yeah, yes. Well, I say the coincidence because the law was revolutionised in this respect, in other respects, by the Family Law Reform Act 1987.
Yes, my lady.
So it's...
And it is exactly the connection with that act which led to the adoption of the policy. That was one of the explanations given insofar as we've been able to look back that far, was that it came in connection with the Family Reform Act.
Yes.
Family Law Reform Act.
Well, it would be very surprising, wouldn't it, if it hadn't?
So, hence the adoption of the policy, under which we say if an application had been made, and the judge confirmed that if an application had been made, the appellant would have been, or the appellant's father would have been successful. The next stage in Parliament's attempt to address the concern is Section 9 of the 2002 Act, which we have at Volume 1, Tab 7, MS page 230.
Can I just ask, in relation to Section 3.1, as Mr. Justice Stingerman sets it out, the father had to be a British citizen.
Yes.
Did the definition of in Section 50, subsection 9, not apply for these purposes?
Well, my lord, no. The way it would have Section 50, subsection 9, effectively operated on Section 2, which was the automatic acquisition.
Yes.
For the purposes of the policy, and Section 3, and I think we have Section 3 in Volume... Do we have Section 3 in Volume 1? No.
Yes, because you see, Section 50, subsection 9 tells you how the expression father and parent is to be construed for the purposes of this Act.
Yeah.
Yes, my lord, but for the purposes of the policy, it was expressed the way it is. So that this was addressed to illegitimate children whose father was a British citizen,
Right.
where the child was living in the United Kingdom,
Yep.
and where the defendant was satisfied. And you just bear with me 1 second. Looking at Section 3, and I apologise for it not being in the bundle. The application is, if while a person is a minor, an application is made for his registration, the Secretary of State may, if he thinks fit, cause him to be registered as such a citizen. So there's no reference to father
It's completely open-ended.
in the section.
Yes.
Yes.
Yes, I see.
And so the Secretary of State could adopt whatever policy he or she wanted as to which applications they would grant.
Yes, my lady. And overcome the difficulty that comes with the definition of father by way of a policy until Parliament could address the issue.
Yep,
Yes.
I see. Thank you.
So that was Section 3 of which provision?
This is Section 3 of the British Nationality Act 1981, which deals with the general power...
As amended or not, or in its original form?
I don't think Section 3.1 has ever been amended.
Right,
my lord,
thank you very much.
It's a general registration power conferred on the Secretary of State.
So in the 1981 Act, you had from the beginning Section 2 birth, Section 3 registration.
My lord, yes. Registration of a minor, I should add. So
Yes.
it's not an open-ended power.
Right.
It's a power to register a minor.
A minor. And the policy operated on Section 3.
and the policy operated on Section 3 to enable the Secretary of State to, on application, remedy the situation of those in the appellant's position who made an application to him for that purpose.
But only while they were a minor.
But only while they're a minor. That's the limit of Section. That limit is imposed by Section 3, which is directed at the registration of.
But that application could be made by anyone, could it?
That certainly could have been made by his father, or one assumes by him if he'd reached the appropriate age.
Yeah. Registration of adults was section 4, wasn't it? Next one down.
So
Birth registration, minor registration, adult.
Yes.
while in his minority, he could have applied.
My lord, yes. He could have applied, and the finding of the judges, he would have succeeded.
Yeah.
Partly because up until the age of 16 there was no good character requirement, and partly because his criminal activities only started once he was once he'd reached the age of majority, and therefore he would have still classified as.
So he was regarded as of good character, whatever activity he'd been up to until he was 18.
Well, certainly there was no activity the Secretary of State was aware of which would have rendered him of not of good character.
Yes, I see.
I think that's the way I have to put it.
Yes, of course.
It's not trying to. If he had committed his manslaughter age 17, I'm fairly sure that he would have not been considered of good character.
Yeah, quite, right.
But we there also, of course, see the long standing of the requirement of good character for the purposes of registering anybody who's over a certain age, here age 16, which we will see later, is of course what Parliament has perpetuated and related any subsequent change of policy to. The next, as I said, the next provision in Parliament's attempt to address the problem is in the Nationality, Immigration and Asylum Act 2002, Volume 1, Tab 7, MS 230, which replaces the old Section 9 by a new...
The old Section 50, subsection 9.
Sorry, the old... Yes, apologise.
Yes.
The old Section 50, subsection 9 is replaced by a new one which sets out a number of categories in relation to when a father will be... when a father can pass on his nationality. And we see for the purpose of this act, a child's father is either the husband, person treated as the father, or any person who satisfies prescribed requirements as to the proof of paternity.
And
again,
I feel fairly sure that subsection 9AA, that is the husband of the woman who gives birth to the child at the time of the child's birth, has to be read in conjunction with section whichever it is of the Family Law Reform Act 1987, which gives an expanded definition to that phrase and includes, for example, legitimated children and all sorts.
My lady, and with legitimated children, of course, we also have Section 47 of the Act, which continues to operate. So that's where we find the new subsection 9, and we then see that the commencement date is to be appointed under Section 162, which you see at MS 242, where Parliament made clear 162 subsection 5 that Section 9 shall have effect in relation to a child born on or after a date appointed by the Secretary of State by order. And just to pause there briefly, again, in our respectful submission, just as in Section 2 we saw, the focus of the assessment in relation to acquisition of nationality is the date of birth under Section 2. This makes clear that again confirms that position, we say. Parliament focuses on the date a child is born to determine what its nationality shall be. And we have, just for completeness, under tab 8, MS 245, the date appointed for the purpose of Section 1625 is the 1st of July 2006. So this was addressing forward-looking from the 1st of July 2006 to put right what the old subsection 9 of paragraph 50 had got where there had been differential treatment, that was corrected as for children born on or after the 1st of July 2006. And of course it is, and we'll get the claim form tomorrow, but we see from Mr. Justice Dingerman's that, of course, certainly the High Court judge who granted permission, Mr. Justice Mostyn, considered that to be the target of the challenge. He identified at MS 121, paragraph 17, that there was a question whether Articles 2 and 3 of the 2006 order are compatible with Article 14.
Sorry, paragraph?
Paragraph 17, my Lord.
Thank you very much. Yeah. The commencement, yeah.
And then, of course, finally, in that history of the legislative developments, we have the 2014 Act, Section 65, in Volume 1, Tab 6, MS 225. We see there, after Section 40D of the British Nationality Act, insert, and then there's a general condition, which is that P was born before the 1st of July 2006. At the time of P's birth, P's mother was not married or was married to a person other than P's natural father. And then we see, relevant to this case at page 227, 4I, subparagraph 1, a person P is entitled to be registered as a British citizen on an application made under this section if he meets the general conditions. 1. 2, P is either an eligible, can I get 2, B, Roman 2, an eligible non-British national. And we see that defined in subsection 3 below, was never a British subject or citizen of the United Kingdom, and had P's mother been married to P's natural father at the time of P's birth, would have automatically become a British subject or citizen of the United Kingdom and colonies. At birth, or then, this is over the page, or by virtue of the British Nationality Act 1981. And then going back to subsection 1, subparagraph C, had P's mother been married to P's natural father at the time of the birth, Roman 2, he would have become a British citizen at commencement by the operation of any provisions of the Act. And it is those provisions which, of course, when the decision under appeal was made, and when this was before Mr. Justice Dingerman's, had not entered into force, had been on the statute book, but had not entered into force. We then have that, of course, being introduced subject to the good character requirement, and this we have in the supplemental bundle at tab C, section 41A. And it is at the third sheet into the tab, my lady, my lords. Slightly smaller print.
Which was the letter?
Sorry, C, my lady.
Sorry.
3 sheets in.
Thank you. Yes.
And then application for registration of an adult or young person as a British citizen. And then we see a whole list of sections up until the square brackets. And just to make the point, so that this requirement for good character already existed for a whole host of powers of registration, including under section 3.1, as you can see there, and was introduced, as the notes tell us, through the Border Citizenship and Immigration Act 2009, with effect from the 13th of January 2010. And then we see in the square brackets added 4F, 4G, 4H, and for our purposes 4I. And again, mandatory that an application for registration must not be granted unless the Secretary of State is satisfied that the adult or young person is of good character. And we see in subsection 5, defined in this section, adult or young person means a person who has attained the age of 10 years at the time when the application is made.
It means, does it, of entirely good character? I mean, this particular claimant doesn't challenge any definition that there might be, but does it mean actually of completely good character?
Well, the Secretary of State needs to be satisfied that he is of good character. I think there is guidance in relation to how the good character requirement applies in the context of registration. But there's no dispute between the parties that having committed the offences he has committed...
This one, there's no problem.
that there is no issue with this one ever satisfying the good character requirement. So that is Parliament seeking to address the issue that arose under the old section 50, subsection 9. A few general points we would draw from that, if we may. One is that in our respectful submission, it is clear from all these provisions, now we'll look at section 47 in a minute, but it's clear from all these provisions that the focus of the determination of a person's nationality is either the date of birth or the date of their registration.
Well, that's why I made this little reference to the relevant section, which I haven't yet looked up, of the Family Law Reform Act 1987. Because references to people being married to one another at the date of somebody's birth are given an extended definition, which is intended to apply to future legislation by that section, in order to cater for the twiddly bits of people whose parents are not married at the time of the birth because of a variety of things, like dad having died before the birth and things like that. So,
My lady, I will have to look that up myself. I've not
it may
made that connection.
It may be a complete red herring, or it may not.
It may not, my lady, and we will look it up overnight if I may. But
Well,
what I will do is I will have to address section 47, which of course deals with legitimation to some extent.
It's not just legitimation that this is about. It's about...
We will have a look at that.
Yeah,
But
well, it may be that it doesn't apply to this, but I'd be surprised if it didn't. And if it introduces a sort of slippery concept of of the birth time, the relevance of the birth time, well then that's obviously relevant to the argument. So we just do have to look at it.
We will have a look overnight.
And my apologies if I've fished a red herring out of...
My lady, this case clearly raises a very difficult issue, and therefore it is only right that we look at all avenues.
Thank you.
You said that the requirement for good character was a long-standing feature of the registration system. Can you just help pin that to something?
Well, my lord, the two ways I said it was the earliest example we have of the good character requirement for registration is the 1987 policy, which required registration for young persons over the age of 16 or over. In the statute, I accept that was only introduced in relation to all forms of registration, as we see listed there, with the 2009 Act in section 41A of the British Nationality Act 1981.
Thank you.
Which was then amended again by the 2014 Act to make reference to section 4I, amongst others.
So statutory form, 2009 Act, amended 2014.
My lord, that's how I understand it, yes.
Yep.
My Lord, again, there is a suggestion from those behind me that there may have been a prior statutory power. If I find it, I will adduce that tomorrow morning, if I may. So I was trying to draw some general points out of the legislation. One is the point of the relevant point for the operation of the law is the date of birth or the date of registration. And it is that which determines for the remainder of a person's life what their civil status in terms of nationality is. In that context, it is important also to note that registration only has prospective effect. So a registration does not lead to retrospective treatment as a citizen from the date of birth, but only has prospective effect and is, in fact, made subject, as is naturalization, to a requirement to swear an oath of allegiance to Her Majesty. Now, in our respectful submission, again, looking back at the decisions, the fact that the appellant has at no stage sought to make an application for registration as a British citizen, and therefore there is no decision refusing him registration as a British citizen, means that, in fact, even if my learned friend were right about the old Section 50, subsection 9, it cannot avail him in relation to the deportation order, certainly not in relation to the requirement in Section 32, subsection 1, that it only applies to people who are not British citizens. Because there is, in fact, no power in law to make somebody a British citizen retrospectively, subject to Section 47, which I will look at in a minute. And that of course, creates one of the difficulties with this case. And of course, my Lady Hale made the point that, in effect, one has to look at this not only by reference to this appellant, who is a criminal and therefore creates particular problems, but more generally. And you identified the category of people who might be in this class and apply for entry clearance and want to come in. You may have seen that Mr. Justice Dingemans, in paragraph 64, recites and I think accepts a submission from me that, of course, the consequences go much further. If, as my learned friend seems to suggest, the only way to remedy the discrimination he says continues to exist, or the historic discrimination as we might classify it, is to automatically confer citizenship on his client, and therefore everybody else in this category, it does raise additional problems. We have this at paragraph 64, MS 130, because, of course, this issue arises in relation to a class of people, the identity and size of which is unknowable.
I think we can assume it's jolly large.
I'm not instructed to make any such assumptions, my lady, but it is certainly unknowable.
Yes, unknowable is good.
And the difficulty with that is that the subjects or the members of this group will live all over the world and may well live in countries where dual nationality is not permitted. Yeah. Or maybe in a civil service job in a country where actually only sole citizens are entitled to have a civil service job. Yeah. And therefore, to follow my learned friend's suggestion would be to deprive those people of their second nationality by operation of the foreign law, of which we don't know, or potentially deprive them of their eligibility to hold the post they hold.
Well, can citizenship be foisted upon you then?
My lord?
Can citizenship be foisted upon you if you don't want it?
Well, it was on us.
My lord, yes. The way the Act operates is...
Oh, yes, it was on us. Some of us may even have wanted it, but...
I'm not sure we were in any position to know at the time.
Yes, no, but I mean, if by operation of law you say that there may be unwilling recipients of the dual citizenship. Is it impossible for them to avoid that consequence?
My lord, the closest they get to avoiding it is by applying to renounce it. But that means they have to have it first. So there must at least be a logical second in which they have it before they can then apply to renounce it. And renunciation is dealt with in a separate section, which again we don't have before the court, which is subject to a number of, it's section 12
Of the 1981 Act.
of the 1981 Act. If any British citizen of full age and capacity makes in the prescribed manner a declaration of renunciation of British citizenship, then subject to subsection 3 and 4, the Secretary of State shall cause the declaration to be registered.
I'm not disparaging the points you're making, don't get me wrong, but the points you make must equally apply as it stands, or as it always stood,
fine.
to children of mothers. Because one imagines there must be, or maybe, a large number of British mothers around the world of children who've never had their births registered in this country and wouldn't know who they were. And it would be a reasonable supposition that a number of them may be in marriages or arrangements under which the child has another nationality.
My lord, that may of course well be true, but of course we're here talking about a category of people who are all now adults, who have arranged their life in order, in reliance on what they knew their civil status to be, namely in this case a Jamaican national, where those who are by operation of law British citizens by virtue of having been born to, for example, a married British couple, would of course have known that and therefore would not have acquired the second nationality because their law doesn't allow it, or would have not because the law of the other state doesn't allow it, or would not have assumed a position, for example, in the civil service because, again, somebody with dual nationality or possibly even eligibility for dual nationality is not eligible for those posts.
Well, I mean, apart from expressing that as a theoretical possibility, is there any evidence that this is a real problem?
My lord,
I think I probably enjoy dual citizenship of Ireland and Britain. It hasn't troubled me much.
But those are two countries who, of course, have no problem with dual nationality.
But I just wonder, I mean, how realistic is it to suggest that this is a difficulty that we should be terribly concerned about?
Well,
It must arise, as my Lord Toulson has really suggested, in many places which allow automatic citizenship either by the jus soli or by the jus sanguinis. And you could have one way and one the other. Must apply in many cases.
my lady, it may well do.
Yeah.
As I said, the approach taken by... Sorry, go a step back. In our answer to your lordship's question, because this has never happened, because as we've seen, Parliament has always prospectively legislated and or legislated by reference to registration, which allows the individual to make a conscious choice as to whether they want to or can afford to assume their British nationality to which they would have been entitled from the date of registration. In that sense, the problem has never arisen. But it has always been one of the arguments put forward, and the closest we have to evidence for what that's worth is in the Hansard extract my learned friend inserted into the bundle at volume 7, tab 82, where we have the minister making exactly that point at page MS 2627. And it's in the left-hand column, third paragraph, as my noble friend Lord Avebury pointed out. Law was changed in 2006. This was not met retrospective because it could have created difficulties for those affected in relation to any other citizenship that they held. For example, some countries do not allow dual nationality, some noble lords will know. And then there's a reference to the 1987 policy. And the requirement for a good character requirement. So it certainly is a consideration that has motivated the government promoting this legislation and Parliament, when it adopted this legislation, to only ever look forward or to provide a power of registration. Now, as I said, I was going to look at section 47, and we have section 47 in volume 1.
It's a matter of interest, you take us that extract. Do we know what the amendment was to which he was addressing himself? Because he says at the foot of column 1, I can't accept my noble friend's amendment because, and then he goes on to the need to consider good character.
My Lord, this is the debate of the 19th of March 2014, so I anticipate he is referring to what then became, because you can see he didn't accept the proposal, what then became section 65 of the Immigration Act 2014.
But this will have been preceded by a heading amendment. We get a comparable example on the right-hand column. Amendment 81 moved by, and the one you can see what they're addressing their minds to.
Yes,
we don't
have that here.
We
If
haven't
the
got
Lordship
that
would like it, we can no doubt produce it.
Well, I'm actually rather more interested to know whether this good character requirement and its reasons, which in some contexts would seem pretty obvious, ever form the subject of any published policy or, for that matter, debate.
My Lord, the answer is beyond this, I don't know. All I can say is this is a debate of March, and the Immigration Act 2014 was debated, received royal assent on the 14th of May 2014, so it was relatively late in the day. And we see that the amendment to section 41A was made, and we see that through the annotation by paragraph 70, subparagraph 3 of Schedule 9 to that very same act. But there is, as indicated, there is a policy on good character which I will, which we'll seek to produce. So I was going to address section 47, if I may, and this is at volume 1, tab 2, MS 212. And really to make two submissions, after having accepted that this is anomalous in a sense to the point I made that all the other provisions I've shown you were forward-looking only and by virtue of birth or registration. And here we have legitimated children. A person born out of wedlock and legitimated by the subsequent marriage of his parents shall, as from the date of the marriage, be treated for the purposes of this act as if he had been born legitimate. Just to pause there, we would respectfully submit, yes, it does have, unlike all the others, does have retrospective effect, but of course it is subject to a conscious decision by the parents to marry, with the consequences the law brings with it. And then subparagraph 2, subsection 2, person shall be deemed for the purposes of this section to have been legitimated by the subsequent marriage of his parents if by the law of the place in which his father was domiciled at the time of the marriage operated immediately or subsequently to legitimate him and not otherwise. So there's a second safeguard, so to speak, by reference to the law of domicile of the father.
Yeah. But is Mr. Southey correct when he says that if it's not going to happen, of course, parents of this appellant were to marry tomorrow, he would become a British citizen?
My Lord, yes. I have to accept that it is an anomalous position and it is an anomalous provision, which is not confined to minors, even though perhaps as the facts of this case show the likelihood of the parents of an adult child marrying may be more remote than it is of an infant child, but that's speculation which I can't really base a submission on. I do accept that it is anomalous, but it is subject to, again, certain safeguards in order to at least minimize the risk of adverse consequences on the individual in question. And it certainly doesn't provide for an automatic conferral of nationality by operation of law only, without there having been a conscious act by, in this case, not the individual, but by his parents, to take a step they haven't previously taken.
Well, can you say in a sentence what the safeguards are?
Well, the safeguards, as I put them, are one, the need of the parents to have made the conscious decision to get married, and B, the reference to the law of legitimation of the country of domicile of the father.
Over which, of course, the offspring has no control at all. And of course, this applies no matter what the age of the offspring. It's not.
My lady, I fully accept that.
He might not want to have.
He might not want his parents to get married, and that may well be right, and it may have consequences for him.
He might well want them to get married if it meant that he wasn't going to be deported. But
my lady, again, perhaps it also addresses the point I made earlier about the unknowable quality and size of the class. This is certainly a class under Section 47, where the individual cases are identifiable, because it has happened, even though they might not be. They might not have consented to it. It required more than just a law saying you are now and have at all times been a British citizen, which is what my learned friend is asking for. The next point I should make is that my learned friend then referred to what I think he at times described as decisions to subject his client to a good character requirement. But of course, insofar as we're looking at his client, there has in fact been no discrete decision in relation to him at all in relation to registration. There's been an adoption of various parliamentary attempts at resolving the issue, and it has resolved it, we would respectfully submit, for the largest part of that unknowable group by enabling them to register, and therefore only leaves the group of those who are in my learned friend's client's category and are not of good character. But there has in fact been, at no stage, a decision in relation to him. And again, we would respectfully submit, it matters when one looks at whether there is a continuing violation, as my learned friend put it, that there hasn't been such a decision. And if one then looks at the way the court dealt with, the Court of Human Rights in Strasbourg dealt with the question of continuous act, we say from the judgment in Posti, Volume 7, tab 74, you've been taken there before, at MS 2386, we see at page 2391 the circumstances of the case and the various decisions at issue, paragraphs 9, 10, and 11. And then at paragraph 15, a decision by the Ombudsman, who considered in May 1995 that the Ministry had not sufficiently taken into account the need for equal treatment of fishermen in different areas. And we then see at paragraph 39 on page 2397 we see the court saying, insofar as the applicants complain that they are victims of a continuing violation to which the 6-month rule does not apply, the court reiterates that the concept of a continuing situation refers to a state of affairs which operates by continuous activities by or on the part of the state to render the applicants victims, and then say, since the applicants' complaints have as their source specific events which occurred on identifiable dates, they cannot be construed as a continuing situation for the purposes of the 6-month rule. The fact that an event has significant consequences over time, such as the restrictions on the applicant's fishing during the specified period, 1996 and subsequent years, does not mean that the event has produced a continuous situation.
So not continuous, although they are still restricted by the decrees made
My Lord, yes.
some years before.
My Lord, yes. So you have the decision made at a point in time, at an identifiable date and time, and we say here that is his date of birth in 1985. The fact that that has continuous significant consequences does not, for the purposes of the Strasbourg case law, in our respectful submission, make it a continuous or continuing situation.
So it's not enough to be guilty, if that's the right expression, of inaction. You've got to take positive action in order to convert it into a...
My Lord, yes. My Lord, yes. And we see, of course, that that is also...
But there was a positive rule. These fishermen were prevented from fishing beyond whatever the quota was.
There was one, but there wasn't one within the 6 months, is I think what
Yeah.
I
Yes,
understood.
that's right.
Yeah, once you're outside the
Yeah.
temporal limitation, you can't come within it again simply by not doing anything.
Yeah, by pleading the consequences rather than actually doing something to rectify it and incurring an adverse decision.
Yeah.
And that, of course, is also consistent with the way the House of Lords has approached this in the context of this issue in the context of nationality law, in the Ross-Clunis decision, which, if you bear with me for a moment, I will... I have mislaid. Just bear with me one second. It's tab 34 in volume 3. At 1060, MS 1069. And we see from the headnote that this also concerned a question under the earlier regime of the 1948 Act of acquiring citizenship, in that case, of the United Kingdom and colonies, which was the concept under the Act. And we see in the speech of Lord Bridge, the only substantive speech in this case, which starts at MS 1073, but importantly at 1076, under the first quote, the word acquired British nationality, here appearing twice in the same sentence, must bear the same meaning, and thus incapable of meaning acquiring citizenship on the coming into force of the Act. They can only refer in each case to the acquisition by the person in question of the status of British subject, either by birth within His Majesty's dominions or by birth out of His Majesty's dominions to a British father. And we then see Mr. Rees's attempt to distinguish it between D and E. We see between F and G, it was open to the respondent's father at any time during the respondent's minority to make application under this provision, and had he done so, there is no reason to doubt that the respondent would have been duly registered as a citizen of the United Kingdom and colonies. Unfortunately, no such application was made, and it is this omission which gives rise to the respondent's present predicament. So there we have an example of the House of Lords adopting a similar process, a similar approach to, in the context of nationality, of a situation which could have been rectified by application, but wasn't so rectified because the father in that case, as in this case, failed to make the relevant application. Can I then just deal, in relation to the issue of a continuous act, you have my submissions on posti. Can I just briefly deal with Loisidou, volume 6, tab 63. That is, of course, one of those cases, one of those rare cases where the court has accepted a continuous act to avoid the application of the 6-month rule. This is volume 6, tab 63, MS 2092. It's been taken to parts of that, but we see at page 2104, paragraph 41, right at the bottom, accordingly, the present case concerns alleged violations of a continuing nature if the applicant, for purposes of Article 1, Protocol 1 and Article 8, can still be regarded, as remains to be examined by the as the legal owner of the land. So the issue really was, had they ever been deprived of the ownership of the land they held in the Turkish-held part of Cyprus by operation of various laws, including the constitution of the Turkish Republic of Northern Cyprus. Of course, very different to this case, where the individual, the appellant, has never held anything of which he could be deprived. Because, as we say, and for reasons I will come to when I have to look at what the state was in 1985, the position then wasn't unlawful. As by operation of law, he was not a British citizen. And we see there in paragraph 42 the reference to the government's argument on which the court will concentrate, last 3 lines of paragraph 42, that the ownership was lost in 1985 as a result of the operation of Article 159 of the TRNC Constitution. You were then taken to paragraphs 43 and 44, which of course record that the international community did not regard the TRNC, this is 44, as a state under international law, and therefore the court cannot attribute legal validity to such provisions as Article 159 of the fundamental law on which the Turkish government rely. It then goes on, however, in 45 to note that international law recognises the legitimacy of certain legal arrangements and transactions in such a situation, for instance, as regards the registrations of birth, death and marriages, the effect of which can be ignored only to the detriment of the inhabitants of the territory, and then conclude that applicants cannot be deemed to have lost title to her property as a result of Article 159. No other facts entailing loss of title have been advanced nor found by the court. In this context, the court notes that the legitimate government of Cyprus have consistently asserted their position that the Greek Cypriot owners of immovable property in the northern part, such as the applicant, have retained their title and should be allowed to resume free use of their possessions, whilst the applicant obviously has taken a similar stance. And it is for those exceptional reasons, namely where there was accepted and asserted ownership of property throughout the relevant period, that the court accepted that the decisions of the Turkish Republic of Northern Cyprus, which wasn't recognised by international law, could not operate so as to terminate that entitlement. And we say that, of course, is a very different scenario from that in the present case, where, in fact, until the date of an adjourned hearing before the first-tier tribunal, no assertion of British nationality was ever made in relation to this appellant. So that's why we say there is no continuous act in this case for the purposes, certainly under the Strasbourg approach. My learned friend also took the court to Courage at volume 6, tab 62, and we would respectfully submit that that doesn't advance this case either, because in that case, the Constitutional Court had already found the position of those who had been deprived of their citizenship unlawful before they joined, and it was that continuing illegality already found by the domestic courts which brought it within the jurisdiction of the court, rather than any suggestion that there was a continuous act or even repeated decisions as postulated by Posty. So if we then come back to the two decisions, there's the decision under appeal in the present case, which is the decision to make the deportation order or not to revoke the deportation order. And looking at it in the context of discrimination, of course, the only discrimination in relation to that decision, certainly on its face, is between a citizen and a foreigner. And we know from the case judgment of the European Court of Human Rights in Mustaqim, amongst others, that those two are not in a comparable situation for the purposes of immigration law. Mustaqim is at volume 6, tab 69, page MS 2304, and the relevant passage is at MS 2317, paragraph 49. In relation to the second decision, i.e. the decision, if one can call it that, in 1985, we have to accept, of course, that the persons there were in a comparable situation and that there was differential treatment by reference to their legitimacy. But we do say that if looked at the time, they were either not within the ambit of the Convention and or were justified. And it is to that which the Court of Appeal drew on the admissibility decision in K and W at volume 5, tab 60, MS 1984, And can I just, at 1964, just ask the Court to note the application number 11278 of 84, become relevant in a minute or two, and then ask the Court to turn to page 1987, where, of course, we see the complaints at page 1987 under the heading complaints. First complaint being that if the second applicant had been female and the first applicant male, the second applicant could easily have obtained Dutch citizenship under the Act of Dutch Citizenship, and this would have prevented his expulsion. In their situation, however, this possibility did not exist, and this constituted a violation of Article 14 in conjunction with Article 8. Again, very similar to the present case, and of course by reference to, just like illegitimacy, one of the sensitive grounds of differentiation and discrimination, namely grounds of sex. And of course, my learned friend used that by reference to Clift as an example for the adoption of policies on grounds of sex, and that would never be authorized. But we see here that that was the complaint. And then under 2, they also complain that the expulsion of the second applicant would constitute an interference with their family life in contravention of Article 8.1. And then over at 1988, and you've seen this already, we see that the Commission recalls that Article 14 of the Convention only prohibits discrimination with respect to the enjoyment of the rights and freedoms set forth in the Convention. It's true that the applicants have invoked Article 8, read in conjunction with Article 14, but the Commission finds that the right to acquire a particular nationality is neither covered by nor sufficiently related to this or any other provision of the Convention, and therefore it was outside the ambit ratione materia of the Convention.
In that case, was there the facility to apply or to have one's father apply to become a Dutch citizen?
No, the scenario in this case was that under the Dutch citizenship law, a woman married to a Dutchman would have had the possibility to obtain this. You find this at 1986, to obtain Dutch nationality simply by writing a letter expressing the wish to do so to the mayor of her town. For him, being a man married to a Dutch woman, this is the 5th paragraph, starting with he also complained.
Yes.
For him as a man, this possibility did not exist. It wasn't about automatic acquisition, but it was about the ease by which a woman could just write a letter to the mayor and that would act as her acquiring Dutch citizenship, while the same did not exist for somebody married to a Dutch woman.
But there isn't exactly a huge analysis, is there, as what, of course, everybody knows that the convention doesn't give anybody a particular right to be the citizen of a particular country. It says that.
Yes.
That's continued through. But it doesn't include any analysis of what aspects of the Article 8 rights might be engaged by the decisions or laws relating to citizenship. And so the nub of the issue is hardly touched upon.
My lady, I accept that, but I have to deal with my learned friend's submission that this is no longer good law, and what I want to do is follow through the case law and show how the court relies on it, but draws a distinction. And if I can start that...
But it's certainly in the realm of Article 8, isn't it?
Well, the court here says it isn't.
Yes, that's
The court says it's outside the convention ratione materiae, so that the court doesn't even have to look at, or the commission in that case, didn't even have to look at, whether Article 14 was satisfied. It was just out with the convention.
Well, leaving this decision aside, on what basis could it be said that it's outside the realm of Article 8? Well, you don't want to leave this decision aside.
We'd say what they're saying. What they're saying, I mean, it may sound odd now, but what they're saying is, you can't get out of Article 8 via Article 14 a right to citizenship.
My lord, yes.
Yeah, well, fair enough. But that doesn't answer the question, whether it's within the realm of Article 8.
No, my lord, and we will have to look at Genovese and why we say Genovese now might pull this into Article 8. But what we say is relevant about this decision. One is that it was made on the 1st of July 1985, so contemporaneous with the appellant's birth. And our case, of course, is that the decision is, or the relevant date for his decision is his date of birth. And secondly, that at that time, the commission took the view that you can't get, or that even the discriminatory denial of nationality does not bring you within the ambit of Article 8 or 14. That's as high as I can put it.
Is there a little bit, before you leave it, I'm sorry, I just want to see, is there a little bit about Article 8 or not on 1989? Not much, but...
No, it then goes on to consider the second complaint, which is the Article 8 expulsion, because we see at 1989, it's true that no right of an alien to enter or reside in a country.
Yeah, that's expulsion.
So that's the immigration aspect of it rather than the...
Yeah, thank you.
So no, we don't get any more of that. But what we do see is, insofar as it was suggested that the court is just sidelining it and rather than overrule it, just cites it and doesn't engage with it. Could I then ask the court to turn to Karasev, tab 61 in the same volume, page 1995. And we see that that is an admissibility decision of the court itself. So the new court. And we see at page MS 2004, under B, right at the bottom, although right to a citizenship is not as such guaranteed by the Convention or its protocols, and we see there the court relying on K and W as authority for that proposition, and no suggestion that it is wrongly decided.
The one in the first brackets is K and W.
That's
is it?
K and W. That's why I asked you to note the reference number, because they hadn't. The court does not exclude that an arbitrary denial of a citizenship might in certain circumstances raise an issue under Article 8 of the Convention because of the impact of such a denial on the private life of the individual. So there we have the court once restating the principle in K and W, and then adding another aspect, namely, the court not excluding that an arbitrary denial of a citizenship might in certain circumstances raise an issue under Article 8.
And are the references there to the East African nations?
That's the East African nations. But of course the East African nations cases weren't concerned with nationality, and therefore, doing the best I can, this is the court pulling together various strands of its jurisprudence to add to what it had said and to qualify K and W, but certainly not to overrule it.
And this is 1996.
This is 1996, but as we see, it is already it's the new full-time court, so
Right.
there's no commission.
No.
But that we say
It
then.
also might be said it didn't really need to overrule it, but it didn't really engage with the failure of K&W to address, frankly, the issue that I'm concerned about, and that is whether this is within the realm of Article 8.
Well, it has certainly, I mean, it doesn't, my lord. What this does is it says under certain circumstances it can be within the realm of Article 8 when there's an arguable issue about arbitrary denial of citizenship.
Yeah. What does that mean, arbitrary denial of citizenship?
Well, the suggestion must be from the case law, and in particular from the case whose name I always forget, even though it's central to this case, from Genovese, that obvious and apparent discrimination in relation to the denial at the stage of the application for registration, which of course was what happened in Genovese. There, the discrimination was patent in relation to the application to registration, which was the issue before the court. That may be enough for the court to say, well, that has the potential of being arbitrary, and therefore it is within the ambit. But what I'm trying to say is that certainly wasn't the position when this appellant was not made a British citizen by operation of the law as it stood in 1985.
What were Mr. Karasev's circumstances? Why didn't he?
Mr. Karasev's circumstances were that there was a dispute. We see that for perhaps best at page 2005.
Thank you.
He was refused recognition of his Finnish citizenship on the basis that there was a dispute about whether he was a Russian citizen. Because
the Finns would not allow dual nationality.
The Finns would not. I was just going to say that the Finns would not allow dual nationality because you can only receive Finnish citizenship by birth on the condition that it does not at that time receive, or the person does not receive citizenship of any other country. So there we have an example of a country who would be affected. And there were disputes, and this was about the time it took to work out the disputes between the Russian and the Finnish authorities. And we see in the penultimate paragraph on page 205, Commission conclusion. So they look at the circumstances of the case. Conclusion seems to be that in 1997 they were not citizens of the Federation, but after having resided in Finland had lost those ties to the country on the basis of which they'd be regarded as citizens. Suggests that those ties may well have existed on the 16th of December 1992, which is the date of birth, which is the relevant time for the purposes of the present case. The parents of the family were citizens of the Russian Federation on the last mentioned date. The applicant may also have acquired the Russian citizenship on that date, i.e. the date of his birth. And therefore, we see over the page, the court therefore concludes that the decision of the Finnish authorities not to recognise the applicant as a citizen of Finland was not arbitrary in a way which could raise issues under Article 8.
Thank you.
And then at the bottom we see...
Well, the next paragraph is also interesting.
As to the consequences of the denial to regard the applicant as a citizen, the court notes that the applicant is not threatened with expulsion from Finland, either alone or together with his parents. His parents have residence permits and aliens' passports and similar documents. So they certainly weren't considering an immigration
And so the court doesn't find that the consequences of a refusal to recognise an applicant as a citizen could be considered sufficiently serious to raise an issue under Article 8.
Yes. And that, of course, in a sense, I'm grateful, my Lord, that, of course, in a sense, applies here too, because a large part, certainly of my learned friend's written case, is by reference to what happened after 1985 to this appellant and his circumstances and the severity of the deportation order.
Yes, I wonder if it perhaps supports your point you made earlier that in the absence of an arbitrary decision to refuse citizenship, Article 8 if Article 8 is going to be engaged, it's because of the consequences of non-citizenship for the enjoyment of various rights and benefits, rather than the non-citizenship itself.
Is Carousel a discrimination case at all?
But we see later on, under 2, that they also rejected the complaint under 14.
Well, they did.
But they do it in a rather...
Yeah.
But it's straight rule, isn't it?
Yeah.
We don't have dual national... I suppose, well, all right, I suppose you could construct an Article 14 argument. You usually can, can't you? Yes.
But it was saying that the consequences in that particular case weren't considered sufficiently
not only
serious.
were they not considered, but it was said that the seriousness of or that they weren't sufficiently serious to raise an issue under Article 6.
But does that not imply that if they were sufficiently serious, it might well raise an issue under Article 8?
Yeah.
Yes, it does.
Yes, I mean, that would be the Courage case, for example, where the consequences of erasure were manifold in these people's everyday lives.
My lady, my
That
lord,
sounds like an incredibly convenient point at which to adjourn before we get on
Be
to
serious.
Genovese tomorrow morning.
Genovese tomorrow morning, my lady.
But not before 11 o'clock
No.
because of the valedictory for Lord Dyson, the Royal Courts of Justice. But we'll look forward to hearing from you then.
Grateful, my lady. My lord.